Justice Jackson.
So I just want to be clear. Are you asking for a special mootness rule for the national security context?
No.
Are we doing some sort of a carve-out for national security?
No, quite the opposite. We rely extensively. I didn't think it was possible to rely more heavily on a case than we do on already. That was a case involving private parties. We think exactly the same rule applies. We do think the national security context does matter for an evaluation of the facts on the ground. I think it's respondent who would have a heightened rule for government officials.
But I guess you keep your argument when you've, in response to other people on the panel, has been there's something about a threat of engaging in terrorism that is the thing that makes this situation one in which we can say with confidence that it won't reoccur. So that sounds to me like it's pivotal to your argument that the Laidlaw standard is satisfied because of the nature of what is going on in this case.
Right. The standard is the same. It's the reasonable expectation of recurrence. So we are not asking for a different legal test in the national security context. My point is that where the thing that has to recur is that an individual poses a threat of engaging in one of 4 enumerated acts of terrorism, that a court should hold is just not likely to recur.
But aren't you skipping over the government's assessment of whether or not that's happening and the basis upon which the government is making that assessment? So this is what I mean, right? The government doesn't, you keep saying it's a totality of circumstances analysis, and I appreciate that. But according to the declaration and everything we understand, the government is making that assessment on the basis of certain criteria. Am I right about that?
I've told you the criteria.
No. I mean even more than that, right? That there's a list, like you say in the declaration, I'm just trying to find it.
It's on 118A.
118, thank you. In the declaration, that he was placed on the no-fly list in accordance with applicable policies and procedures. So there is some policy that the government looks at in each case when it's assessing on the totality of the circumstances whether or not a person qualifies, right?
So the policies referred to there is the standard I just gave you.
It's at that level of generality. A person can't make an argument that the government, in applying that standard, has used certain criteria that I'm challenging with respect to my application.
No, I've given you the criteria for placement on the no-fly list. You also have to satisfy placement on the broader watch list, which is reasonable suspicion that you are, they call it a KST, a known or suspected terrorist.
All right, so if a person wants to argue and their claim that they're bringing in their lawsuit is that the government was mistaken about its assessment that my conduct qualified under the standard that you have articulated, and then the government does not say, we've changed the way we looked at what you did before, we've changed the criteria that we use to assess it or anything. The government just says, okay, you're now off the list, and we think the case is moot as a result. Why does the court have some sort of reassurance that the government wouldn't look at the situation down the line and make the same assessment?
Because in this case, if it's as you just said, if I heard you right, then I agree. That would pose a much tougher case. But here we have 2 additional things. One, the Courtright declaration that we were just reading makes clear that he was removed from the list not just as a matter of grace or because we wanted to moot out the litigation, but he was removed from the list because he substantively didn't satisfy the criteria anymore. And that, under the presumption of good faith and national security, is entitled to respect, and absent some strong showing of bad faith. And then second, the Courtright declaration says, and we're not going to reconsider this decision because you won't be put back on the no-fly list based on the currently available information. So it adds a stickiness to that determination. So it's not a matter of grace, and it's sticky, and so isn't lightly going to be revoked.
All right, let me ask you about the standing question real quick. Does the government dispute that Mr. Fikre had standing at the time that he filed his suit in 2013?
No.
All right, so he did, and don't we ordinarily assess standing at the time the person brings the lawsuit? If you have standing to file the lawsuit, then to the extent your circumstances change, we now move into the realm of evaluating it under mootness, right?
That's correct, but I'll point out that already, which was a case about mootness, did mention that, in these circumstances where the claim is no longer really live, that cases like Lyons and Article 3 apply with equal force, that a litigant cannot just rely on speculative injuries to keep the case alive. So mootness and standing should not be interpreted to be that different from each other, because both are implementing Article 3's case or controversy requirement. And that's why, as I was mentioning to Justice Kavanaugh earlier, I think we shouldn't interpret the two exceptions to mootness that make it more flexible than standing, unmoored from the purposes for which those exceptions were developed, which was really evasion of judicial review, and in particular with voluntary secession.
Justice Scalia suggested that the voluntary secession exception really is about whether or not the case is moot to begin with. It's not as though we're accepting that it's moot under a circumstance in which the government takes him off the no-fly list, and then we're looking at, is there an exception to mootness in this situation? Instead, we're saying, has the government actually mooted the case when it takes him off the no-fly list, right?
Well, I'm not sure about that. I mean, Justice Scalia dissented in Friends of the Earth, and he actually would have accepted the mootness as just standing in a time frame. And so if you accept that, we're happy if you accept that, because we definitely win this case then. There's no question that if respondent had filed his suit the day after being removed from the no-fly list, he wouldn't have had standing at all, and there would be no Article 3 jurisdiction there. So really, to keep his no-fly list claims alive really does depend on this delta between mootness and standing, even though both implement Article 3. And the only way to get there is through voluntary cessation. And there, I think you shouldn't interpret it to be so unmoored from its purposes.
Thank you.
Thank you, counsel.